We've had a few quiet years on employment law updates. COVID and things like that have made everything else very complicated, but we haven't seen much in terms of legislation updates. And 2024, that all comes to a change. We've got quite a few coming in. So in this video, I'm just doing a quick roundup of the employment law updates for 2024. For those who don't know me, my name's Jenefer. I'm the founder of Silk Helix, and we work with businesses to keep you employment law compliant, but more importantly, to make sure you're getting the best out of your people with the foundations of that compliance. So let's start off with those expected to come into force in April this year, which is most of them, to be fair. So we'll start off with flexible working. Flexible working, the right to request flexible working. Bear that in mind, it's a right to request, not a right to have. But the big change coming in April is that this will become a day one right. So we can still turn it down for business reasons. There was an expectation that those would narrow. That's not happened. We can turn it down still, however it can be requested from day one. This does have some interesting implications. It might mean that you want to start considering it and thinking about it even from recruitment, because if you recruit somebody and they come in on day one and ask for flexible working, that may have some implications to think about. But is there flexible working? It's not a huge change except for the fact that it is becoming that day one right. We've also got the introduction of carers leave. So carers leave will be the right to have up to a week off in each year, can be taken in as little as half days, doesn't have to be consecutive. But for people who are caring for a dependent with long-term care needs or with a terminal illness. So this provides extra support for those people who perhaps are caring more for adults than children, because children tend to be covered by parental leave. And don't forget, we've got time off for dependents, which is already there as well. So it just adds that extra week onto the family-friendly leave entitlements that we've already got. Talking about family-friendly leave entitlements, the protection against redundancy. So this is in particular the right to be offered suitable alternative employment is being extended. So the maternity leave, adoption leave and shared parental leave regulations will extend the period. So it'll be from a period of 18 months from the date of birth of the child or the expected week of childbirth if we're not sure the actual date of birth. So it'll be an 18-month period. So whereas currently that protection stops at the end of the period of leave, now that's going to be continuing once they come back to work. If we're still within that 18-month period, which we will be for some time, then you've still got that protection against redundancy. Now, this doesn't mean that we can't make people redundant, but it does mean that we have to offer suitable alternative employment where it's available. Forgive the quick interruption to this video, and I will keep it really quick. If you've liked this video, found it useful, you can of course hit the subscribe button. But I also want to tell you about our digital courses. In our digital courses, I go into much more detail. The videos are very similar to these. It's me, it's on camera, but there's also downloads, there's sample forms, there's a few sample policies in there as well. All the things that you need to know. We've even got some coming where we've got live classes as well. So check out our digital courses. Details are on screen now and in the description below. Look forward to seeing you on one of our courses in the future, and in the meantime, I'll let you get back to the video. Holiday pay. Now, we've had a flurry of case law in recent years. I say recent years, I think it's been going on nearly 10 years now. A varying case law telling us how we calculate holiday pay, what should be included, what shouldn't be included. And then a few bits of legislation now coming in to clarify for us what we can, what we can't do. And in this case, change really what the case law has said, and that's about rolled up holiday pay. So rolled up holiday pay is where we pay 12.07% in addition to the hourly rate for each hour worked to cover periods of holiday. This was quite commonly used for people who had variable hours. It was then determined in case law that it deterred people from taking holiday. We've now got legislation coming in that specifically says that where people are part-year workers and hours are wholly or mostly variable, then employers can choose whether they use the 12.07% rolled up holiday pay calculation or whether they use the 52-week average pay calculation. The challenge for some employers will be that holiday pay is written into employment contracts to define how we do that, so changing it may be difficult. Having said that, the average is often not been liked by employers and employees alike, because nobody can really work out on an ongoing basis what entitlement is, what they've got accrued. It causes all sorts of complications. So actually for me, I think this is a huge relief for employers, because administratively not being able to use rolled up holiday pay is so challenging, particularly where people's hours vary hugely or they work part year. So I think this is a really good thing for employers. Could be a little complex in terms of making decisions to implement it, and say check out my videos on holiday pay to look into this in detail. Seek advice as well for the implications, but this is a key one for employers and really worth knowing about, and could take away a lot of the administrative burden for some employers when it comes to calculating holiday pay for workers who are working really variable hours. And finally, coming into force towards the end of 2024, we will have the Worker Protection Amendments to the Equality Act 2010, which will place a duty on employers to make reasonable steps to prevent sexual harassment in the workplace. This is quite key, it's quite a big change for employers. It will likely mean that employers will need a policy and to provide training to employees on prevention of sexual harassment, ensuring that workplace cultures are centred around preventing sexual harassment, so the ability to report it, people knowing what to do when it's reported, people knowing what sexual harassment is, what to do if they witness it. All of these things will become a duty on employers to have provided training on and a policy. We are still waiting for detailed guidance on what reasonable steps really does look like, but it is expected that it will include policies and training. And that's something we'll be working towards, making sure that our clients have got training included within their package to share with their employees to cover them, as well as having the policies in place to make sure that they're compliant with that legislation. I will be doing more videos on that nearer the time, so do subscribe to make sure you don't miss those videos. You can also join our mailing list so you keep up to date, and we'll make sure that you're given the information as and when we've got it. Details are in the description below on how to sign up to our mailing list. So there you have it, that's the roundup of 2024. I have got specific videos on each of those and more to come as well, so that you're kept up to date and you know exactly what the changes are. We work with employers to update policies, give HR advice and do management training. So if you need any of those things, check out the description below for details of how you can work with us. In the meantime, don't forget to hit that subscribe button and I'll see you on the next video.